So, good afternoon, everyone. Thank you very much for joining our webinar today. I am Emma Waldron and I'm WCVA's Risk, Procurement and Governance Manager, and I'm also WCVA's Data Protection Officer. So this is our fourth webinar of the Desktop Data series, and these sessions have been arranged to help you prepare for the new GDPR, which comes into place in May 2018. And I'm delighted to welcome our speaker, Bethan Bonsall from the ICO.
Hello.
Bethan's here to discuss privacy notices and consent today, and we anticipate that today's session should last about 30 to 40 minutes. There'll be an opportunity for questions as well, so if you can just add them to the chat pane as we're going through, and we'll answer them at the earliest opportunity. Okay, over to you, Bethan.
Thanks, Emma, and thanks to you all for joining our fourth Desktop Data webinar. It's good to see that so many of you have an interest in the importance of getting privacy notices and consent right, so I hope that this webinar will prove useful to everyone dialing in. So many of you listening today will be familiar with the role of the Information Commissioner's Office, but for those of you who aren't so familiar, I'll just give you a bit of background as to our role. The ICO is responsible for upholding information rights in the UK, so as part of that we regulate the Data Protection Act, in addition to associated information rights legislation, and it's data protection that will form the main basis of today's webinar. As many of you will know, in just over 270 days, the Data Protection Act will be replaced with the General Data Protection Regulation, or GDPR for short, which will apply in the UK from the 25th of May 2018. GDPR is the biggest change to data protection laws in a generation, so preparing for it is absolutely key. The ICO will be the UK regulator for the GDPR, so a large part of our role, like it is with the Data Protection Act, is to provide advice and guidance to you organisations to help you comply with the laws that we regulate. As Emma said, I'm Bethan Bonsall and I'm the lead policy officer for the ICO's office in Wales, and part of my remit is to help the voluntary sector in Wales by doing webinars like today's. We also do other awareness raising sessions. So let's quickly take a look at what we'll be covering. The main purpose of today's webinar will be to look at privacy notices, as it says on the tin. We'll be looking at why providing effective privacy information is important, what you should include in your notice, and where you should deliver your privacy information and how to write an effective notice. Now, we'll also be looking a bit at consent. There's a fundamental difference between telling people what you're going to do with their data and gaining their consent in order to process that data. Although in many cases it's enough to be transparent and rely on a legal basis other than consent, in other situations a positive indication of the individual's agreement will be needed if you are relying on consent as a legal basis. It's important to look at what you currently hold as an organisation and determine whether any of what you do process does require you to seek the consent of the individual. If it does, you'll need to look at the mechanisms you use to obtain that consent, because GDPR, and we'll see a bit later how it does this, GDPR raises the bar in terms of how you obtain and manage consent, so we will look at those requirements a bit later on. And finally, I think I've already mentioned it a few times, but throughout the webinar we'll be referencing the General Data Protection Regulation and explaining why getting both privacy notices and consent right ahead of May next year is so important. So first of all, let's look at what a privacy notice is. The term privacy notice can be used to describe all of the privacy information that you make available or provide to individuals when you collect information about them. A privacy notice therefore doesn't just mean one piece of paper given to an individual with terms and conditions on it. The ICO believes it's good practice to develop a blended approach, using a number of different techniques to present information to individuals. So techniques include things like hard copy notices, those notices that you find on the bottom of websites, and even signs presented in a public reception area, for example. You can use the various techniques available in whatever combination is most effective for your charity. Privacy notices encompass part of your obligations under Principle 1 of the Data Protection Act. So many of you dialing in today might be quite familiar with how the Data Protection Act works, but for those of you who aren't, Principle 1 basically states that all personal information that you collect shall be processed fairly and lawfully. Although having an effective privacy notice doesn't mean that you're complying with all aspects of Principle 1, giving an effective privacy notice allows individuals to have greater choice and control over how their personal data is used, and it ensures that what you're planning on doing with their data that you collect won't come as a surprise to that individual. And as we mentioned, getting privacy notices right is already a legal obligation under the current Data Protection Act that we're all complying with. But what about under GDPR? So the General Data Protection Regulation strengthens the rights that individuals have in relation to their own information. And one way it does that is by introducing a new right called the right to be informed. This right encompasses your existing obligation to tell people what you're going to do with their data, but it also emphasises the transparency by setting out explicitly what information should be supplied to individuals and when they should be informed. Much of the information you should supply under the GDPR will already be consistent with what you're meant to be supplying under the current Data Protection Act, but there is a couple of bits of further information that you're explicitly required to supply. So the main changes can be found in a really useful piece of guidance that we've got called the Overview of the GDPR document, which is that document that you can see on the right-hand side of your screen. So if you haven't already downloaded that or you haven't seen that on our website, then I would suggest having a look at it. You can access it by the URL on the left-hand side of the screen there, but if you can't write that down, if you just go to the ICO's website and type in DP Reform to the search facility, that will hopefully be one of the first links. So we've had a bit of a look at what a privacy notice is, and we've learned that it's not just one notice. You can adopt blended approaches to tell people what you're doing with their data. But what should you include in your privacy notices? At the most basic level, the starting point of any privacy notice should be to tell people who you are, what you're going to do with their information, and who it will be shared with if applicable. These are the basics upon which all privacy notices should be built. However, you can tell people more than just this, and should certainly do so where you think that not telling people something about the processing will make that processing unfair. So this could be the case if an individual is unlikely to expect that you'll use their data in a particular way. We've already discussed the fact that the GDPR will increase the amount of information you provide in order to meet your obligations under the new right to be informed. This additional information includes, first of all, stating what legal basis you're relying on under the GDPR. And we'll be having a more detailed look at legal basis later on in the presentation. But also giving individuals details about the length of time you'll retain the individual's data for. So again, it's important to also not just look at your privacy notices, but make sure you've got clear retention policies in place across your charity. GDPR will require privacy notices to be delivered in a clear and concise manner, which are written in clear and plain language, whether that's English, Welsh or both, particularly if they're addressed to children. And they also must be provided free of charge, so you can't charge individuals for accessing privacy information. Now, earlier on, I referred to a table in our GDPR overview document that sets out what information you'll be required to provide in privacy notices. And on the screen there, you'll see a little snippet of that table. The full table can be found on page 14 of the overview document. And as you can see, it really clearly explains what information must be supplied to individuals and at what stage. So the stage and the timing depends on whether that data has been obtained directly from the individual or whether you've obtained it from other sources. I think it's always nice to have a bit of interaction in these webinars because you're probably fed up of listening to me. So I think before we go on, it's just a good opportunity to carry out a quick poll and just get a feel for where you think at this stage your organisation is in terms of preparing for GDPR. So have a think about the privacy notices and the way that you tell individuals what you're doing with their data. And have a think about, given the increased information that GDPR requires you to include, think about whether you feel confident that at this stage your notices will be ready for GDPR come May next year. So if I could ask those who think that they are confident to vote agree if you're happy that you already provide a sufficient information. I think whether that's because you've already reviewed them or whether actually under the Data Protection Act you already went above and beyond and included that additional information. If you think that there's a bit of scope to review your privacy notices, then click disagree, that you don't feel that you're ready for GDPR in terms of privacy notices. But please don't worry, because again, there's going to be a lot of information coming out. There's a lot of time to get these looked at, and that's why it's key that you're dialing into today's webinar, because we've still got just over 270 days to go.
Brilliant. Okay, thanks, Bethan. So looking at the results at the moment, it's those that have indicated yes, they feel confident about their privacy notices. We're looking at 61% and 38% for no. Perhaps I think we've got about 13 people that have indicated their choice.
And again, I can't stress enough that if you don't feel confident, there's so much guidance out there. There's webinars such as today, there's the GDPR overview document, there's a wealth of guidance available from the ICO's website, and certainly WCVA are there to help as well.
Okay, great.
Well,
thank you.
Thank you, and hopefully through these next few slides, you'll start to feel a bit more confident in terms of what you need to do to get to that stage where you are happy that your privacy notices are ready for GDPR. Thanks, everyone. So we've looked at what privacy notices are, but how do you get that information across to individuals? So once you've drafted your privacy notice, how do you then communicate that privacy information to the individuals that you're collecting information about? You shouldn't necessarily restrict your privacy notice to a single document or page on your website. Although we use the term privacy notice, it's often used as a shorthand term, but rather than seeing the task as delivering one single notice, it's better to think of it as providing privacy information in a range of ways. So first of all, you can provide privacy notices orally, so either face-to-face when you speak to a customer, or over the phone. You can provide them in writing, so in printed media, adverts, forms such as financial applications or job application forms. You can also provide that information through signage, for example, an information poster in a public area. And finally, you can also do so electronically, whether that's in things such as text messages, websites, emails, and mobile apps. It's always good practice to use the medium that you use to collect personal information to deliver those privacy notices. So if you're collecting the information through an online form, you could provide a notice just as the individual fills out the form, so what we call it a just-in-time notice. It wouldn't be good practice to collect the information by online forms and then send out an email afterwards with a link to privacy notice, because by this point the individual has already given you their data without knowing what you're going to do with it. So it's kind of removing their choice and control over whether they give you their information. We recognise that in some contexts it can actually be difficult to communicate a privacy notice to individuals. For example, in an emergency situation, sometimes obtaining personal details of someone quickly can be quite critical to protecting that individual. So in cases like that, you should explain how you use that information and at an appropriate point later on, or if you can't provide privacy information for whatever reason, it's particularly important that you only use the information you collect in a way that members of the public are likely to anticipate and agree to. Now, adopting a layered approach for delivering privacy information can be useful, as it allows you to provide the key information immediately to that individual, and then have more detailed information available elsewhere for those that want it. This can be used where there's not enough space to provide more detail, for example, or if you need to explain a particularly complicated information system to people. Now, as you can see on the example on your screen, it usually consists of a short notice containing key information, such as your identity and the way that you'll then go on to use that information, but it also may contain a link that then either expands that section or links to a second, longer notice that provides more detailed information. So we call that layered privacy notice approach. And I'd mentioned briefly earlier the concept of just-in-time notices. So these are, and you can see one on your screen, these are a tool that you can use to provide relevant and focused privacy information in certain situations. So this is another type of layered approach to provide information at certain points of data collection. Just-in-time notices work by appearing on the individual screen at the point where they input personal data, providing a brief message explaining how the information they're about to provide will be used. So you can see this in practice on the slide at the moment. At the point the customer inputs their email address, the text at the side appears to inform them how their data will be used. And because it's only a small speech bubble with limited space, this is also a really good example of adopting a layered approach, because the customer can then click on that link to find out more. So the information isn't all contained within that bubble, but if they do want it, it's easily accessible just by clicking on that link. Now, I'm quite aware that this is quite a detailed topic and many of you might have questions at this stage. So if anyone does have any questions, I would invite you to ask them at this stage, whether it's something that I've glossed over and you'd like to just me to expand on a bit, or whether there's anything that I've explained that I haven't explained in a kind of thorough enough manner. So if we do have any questions, if you're happy to type them now, we'll try our best to answer them before we move on.
Great. Okay, so we have a one question coming in, and this is from Marie. No pressure, Marie. Yeah, and if anybody has any other questions, feel free to add them in.
Yeah.
We do appreciate that this is a very detailed topic. So, thank you very much, Marie. Where can we find examples of the notices that we may need?
Well, thanks for that question, Marie. Because we're the independent regulator, we don't have kind of stock privacy notices that organisations can use as a template. But we do have a really good code of practice. It's called Privacy Notices, Transparency and Control. If you just type in privacy notices to the ICO's website, it links to a really useful document that does, I think in the annex, it contains a couple of examples, but also it contains a couple of examples throughout. For example, the slide that you're looking at the moment about the just-in-time notices, that was actually taken from our privacy notices code of practice. So if you haven't had a look at that yet, I would really suggest that, because it's a nice starting point for those of you that are hoping to review your privacy notices ahead of the law changing next year. Thanks, Marie.
Okay. And there aren't any more questions at the moment, so we'll just carry on with the presentation then.
Yeah, and then we'll have questions at the end. So for those of you that haven't thought of any yet, keep them coming. So a big part of my role, as I said earlier, is to go out and about and talk to stakeholders and help them to get things right under the laws that the ICO regulates. And one of the most common questions I do get asked when I am out and about is when should we actively communicate that privacy information? So there's two different things. There's having that privacy information available on a website, for example, for someone to look at if they have time. But then there's also sometimes situations where you do need to actively get that information across to the individual at the point where you collect that data. So to answer this question, you really need to put yourself in the shoes of the people you're collecting the information about, which includes understanding the level of knowledge that they'll have about how their data will be used. This will then help you to decide when to actively give them that privacy information. So if it's reasonable for someone to expect that you'll use their data for an intended purpose, you're less likely to need to actively explain to them what you're doing with that data, and can instead make privacy information available if they look for it. However, there are certain situations when someone wouldn't reasonably expect you to use their information in the way that you're intending to, and the need to actively communicate privacy information is strongest in the following situations. So firstly, if you're collecting sensitive information, this will usually require you to communicate privacy information actively. Those of you with some experience of working with data protection laws will know that sensitive personal data includes information relating to things such as health, sexual orientation, political affiliation, and trade union membership. That's not the exhaustive list. The full list can be found on the ICO's website. So if you're using any kind of sensitive data as defined by the Data Protection Act, then the need to actively give them that privacy information will be strong. Secondly, if you're intending on using the information in a way that the individual is unlikely to expect, or in a way that they'd object to, then you'll need to consider actively communicating privacy information. If providing personal information, or if failing to provide it, will have a significant effect on that individual, the need to actively communicate information will be strong. And finally, you'll need to communicate privacy information if you're going to share the information with another organisation in an unexpected way. If you're struggling to determine what someone would reasonably expect you to do with their data, you could undertake some research with customers or people that have contact with your charity or the wider public, explaining what it is you want to do with data, and from that, gauge whether they'd reasonably expect you to do what you're planning. So you could do this by using things such as focus groups or online questionnaires. If you're planning on doing something similar to what you've done in the past, review whether you had any issues prior to that when implementing that processing. And in fact, also consider whether you received any complaints about it, because the more complaints that you got about that processing, I think it's fair to say the more that individuals wouldn't have been likely to expect what you were doing. And you could also look at the experience of similar charities in your sector to see if there has been an approach that's been used that works particularly well. If you decide that you do need to actively communicate privacy information, you can do this in a number of ways. So the first one, you could contact individuals directly by either post or email. You could deliver the relevant information by reading out a script, so whether that's face-to-face or over the telephone when talking to donors or other people that have contact with your charity. And you can also provide interactive information in an online form to explain why you need their particular information, or you can deliver it when the individual hovers over a particular field when completing a form online. So similar to that example we saw earlier of a just-in-time notice. So when that individual went to input their email address, they hovered over that little button and a little speech bubble popped up with some nice privacy information in it. So I referred to GDPR a number of times throughout this webinar, but let's take a closer look at what the actual law change requires in terms of privacy notices. So for those of you who may have missed the beginning of this webinar, GDPR stands for the General Data Protection Regulation, and it's the law that will replace the current Data Protection Act next May. As I've already mentioned, much of what you do need to supply under the GDPR is consistent with the type of information you're already obliged to supply under the Data Protection Act. So for many of you, there won't be a lot of work to do because you might be happy that you've already got that information in your privacy notices. However, there is a shift under GDPR to move away from using language that individuals are unlikely to understand, or setting out your privacy notices in ways that people will struggle to digest because it's not written in a clear enough style. So I think many of us have probably read terms and conditions that go on for pages and pages, and by the end of it you've clicked next page 5 times and you're still not sure what the organisation is planning on doing with your data. So luckily GDPR says goodbye to those horribly worded privacy notices and really stresses the need to write them in a clear and concise manner. So that's why GDPR will require you to write them in a way that's both concise and transparent, but also intelligible and easily accessible. So you can't have a privacy notice buried in the darkest depths of your intranet or your internet. You've got to have it easily accessible to those that would like to see it. You'll need to write your notices in clear and plain English or Welsh or both. And they'll also need to be free of charge, so you can't charge someone to access your privacy notice. And the fact that the law is changing means that you've got a really strong incentive to review what you're telling people now about the way that you use their data. So some of you might have delved into our fundraising webinar back in June, and if you did, you'll remember that the ICO took enforcement action against a number of charities who were using people's data for the purposes of wealth profiling. So they were looking at donors and they were assessing how likely they were to give another donation or likely to leave a legacy donation. Now, they were doing this profiling without telling people that they were doing so, which made it inherently unfair, as those individuals had no choice and control over how their data was used, because they'd never been made aware that that was happening in a privacy notice or in a face-to-face discussion, etc. So this emphasises the importance of getting your privacy notices right now while you still have time ahead of GDPR. And again, hopefully this webinar will assist, but also the guidance on our website will also help you to take you through that process of reviewing what you tell individuals at this stage. So although the main focus of today's webinar has been on the requirements and importance of privacy notices, another area that you will need to review ahead of GDPR coming in is the issue of consent. We've looked at the importance of ensuring that individuals are told how their information will be used by an organisation, but this is sometimes confused with getting people's consent to use that information. Fair processing and consent to use information are two very different things. So this will hopefully make sense if I explain it in simple terms. So if we look at the wording of Principle 1 of the DPA, it states that all personal information must be processed fairly and lawfully. So if we break it down into the two components, this will become clearer hopefully. So first of all, fairness. Fairness requires you to tell people what you're doing with the data, such as in the privacy notices that we've discussed. It also requires you to not use personal data in ways that will be inherently unfair to individuals. Now, because it's both fair and lawful, the lawfulness requirements of Principle 1 mean that you can't just collect information because you think it will be useful to your charity. You have to make sure you have a legal basis for using that data. And under the Data Protection Act, we call these legal bases Schedule 2 conditions because they're set out in Schedule 2 of the Data Protection Act. If you're collecting sensitive information, so things such as health, religious beliefs, etc., you'll also need to meet a condition in Schedule 3, but I know that that's very technical. Again, I'm happy to take questions later, but we do have a lot of useful information on the website. But I think the easiest way to think of these little conditions is to think of them as little hoops to jump through before you can then go on to collect that person's information. So we'll look at these little hoops in more detail, but please remember that this is only a quick overview of Principle 1, so it may well be the case that you have further questions about your particular charity. And if you do, then I'll put my contact details at the end. But whilst we can't tell you which legal basis is appropriate, because we're the independent regulator, we can certainly provide advice and guidance. So if any of this does leave you feeling overwhelmed, please don't hesitate to let us know at the end and contact either WCVA or myself at the Wales office. So back to those little hoops to jump through, so those lawful conditions. There are 6 available under the Data Protection Act, and these 6 are very similar to those that will be available under GDPR, but for the sake of today's webinar, I'll just be referring to the actual wording of the current Data Protection Act. Now, there's been some myths surrounding the current law and the GDPR, one of those being that all organisations must get people's consent before continuing to use their data. I can't stress enough, this is absolutely not true. So under both the existing Data Protection Act and under GDPR, consent is still one of 6 legal bases to use someone's personal data. So we're going to take a look at the 6 conditions that are available to you as charities. And I think we're starting off with consent, which we have discussed. So basically, the first reason you might use someone's personal data is because you have the consent of that individual. So for example, you might ask donors to your charity whether they're happy to receive marketing emails. So just to make it a bit more interactive, we're just going to have a bit of a straw poll again and just a bit of interaction on this slide, just to get a feel for which of the lawful conditions you think your charity uses at the moment. So there's no right or wrong answer with these. It might be that you're not sure. So if you're not sure, then you can vote whichever you're tending to go for, or not vote at all. That's fine. So first of all, have a think about whether you use consent as any legal basis for any of the areas within your charity. If you can think of an area where you do rely on consent, so you go out and ask people for their consent to then use their data, then click agree. And if you can't think of anywhere within your charity that you do use consent, then it's absolutely fine to click disagree. So again, this isn't a test, this is just for us to get a feel for what conditions are being used.
Okay, so it looks like we've had a few issues with the sound a minute. So can you just repeat, Bethan, the section about consent? And first of all, can we just confirm that everybody can hear me? Please, if you can just type into the chat pane. Yeah, brilliant. Okay,
Right.
So if we can just go back through consent.
Yeah, so I think someone asked what was the myth that I was talking about. So basically, there's 6 little conditions that you can rely on to use personal data under the Data Protection Act. There's been myths surrounding GDPR and what you'll need to do when the law changes. And one of those myths is that GDPR is all about consent. So any personal data that you use as a charity, you'll have to go and seek consent of everyone that you collect data about. Now, this is absolutely not true. So under both the existing Data Protection Act and under GDPR, consent is still one of 6 completely valid bases to use someone's personal data. So we're just going to have a little run through which options are available. And we're also going to make it a bit interactive as well. So the first one we're looking at is consent. And what I want you to do is have a think about your charity and whether there's any areas of your charity where you ask individuals for their consent to then use their data. So it might be within a marketing arm. It might be if you're asking them to consent to receiving postal marketing, electronic marketing. So if you do have a think and you know that there's an area within your charity that you do use consent, if you could vote agree. If you can't think of anywhere, then vote disagree, because it's absolutely fine. There's no right or wrong answer. It's just for us to get a bit of a feel for what conditions are being used. So if you could vote now, that'd be great.
So if you go to the icon where there's a picture of someone raising their hand, if you click on the arrow there, there should be some agree, a variety of options. So you'll see agree and disagree on there. So at the moment we have lots of agrees, or 3 agrees, Brilliant. So just to
Well.
confirm, it's right at the top of the page, next to the speaker icon. There's a greyed out image of someone raising their hand, and then there's an arrow next to it. When you click on the arrow, then there should be some options there. If not, then please can you just type it into the chat pane? And apologies, it seems that we still have issues with the sound. Okay, brilliant. It looks like the majority agree,
Well,
which is great. Okay.
thank you.
Thank you.
And it's useful for us to know what conditions are being used, just to kind of get an understanding. Okay, so we've looked at consent. Now, the second reason you might use someone's personal data is because you need that information in order to perform a contract. So an example being, your HR department needs to collect employee data in order to pay employees each month. You wouldn't realistically ask for an employee's consent to use their bank details, because without those details, you wouldn't be able to pay them. So this condition would be most appropriate in that scenario. So I'm probably expecting a lot of hands for this, but if you can think of an area where you do use the reason to perform a contract in order to collect personal data, then if you're happy to either select agree or disagree. And again, this one is likely to be used in those with HR departments. So we're all from organisations that hopefully pay employees. So you would more than likely have this as your legal basis. Well, we've got a few agrees.
Yeah, quite a lot of agrees there. And again, if you can't, if you're not able to use that function, then please just type into the chat pane.
Thank you. So a third reason that you might use someone's personal data would be in order to comply with a legal obligation. So an example of this might be that you're required by law to pass certain personal information about your charity's work back to Welsh Government. Again, you wouldn't ask for the consent of the individual involved if you had to pass that data legally to a third party as part of a legal obligation. Because if that individual then said no, you'd still have to pass that on regardless. So asking their consent is quite unfair, because you're saying, do you consent? At the point where they say no, you then have to do that processing anyway. So have a think about your charity and how it's set up, and have a think about whether any personal data that you process does need to be processed for the purpose of complying with a legal obligation. And again, I don't expect everyone to know the ins and outs of their charity, but if you do have a think and you think it is used, then if you could press agree, and if you can't think of anywhere that it is used, then it's fine, it's absolutely fine to press disagree. Well, so we've got quite a few agrees, as I'd expect, given the third sector, so that's interesting, thank you. Fourthly, in some circumstances, information needs to be used or disclosed in order to protect the vital interests of an individual. So this condition should only be relied upon in cases of life or death, such as where an individual's medical history is disclosed to a hospital's A&E department who's treating them after a serious accident. This condition should only be used on a case-by-case basis and not in a blanket manner. So for that reason, I won't ask whether anyone uses this, but it's just important for me to make you aware that this is a completely valid basis in certain circumstances. And I just want everyone to remember that the Data Protection Act would never stop the sharing of information if that sharing were to protect the vital interests of an individual. Now, in some organisations, the use of personal data is necessary for things such as administering justice or for exercising statutory, governmental or other public functions. I think due to the fact that the attendees today are primarily third sector rather than public, I won't ask you to vote on this one. But again, like vital interests, it's a completely valid basis, as are all of these on the screen. And then lastly, there's a condition for processing called legitimate interest. So if the use of personal data would fall within your organisation's legitimate interest, as long as what you're hoping to do with that data doesn't kind of override the fundamental rights of privacy of the individual, and provided that you actually need that data in order to pursue your legitimate interest, then this is also a valid basis under the Data Protection Act and will be under GDPR as well. So it might be worth having a think about an area of your charity where you might use personal data but you don't necessarily actively go and seek consent from individuals involved. Again, I'm not expecting everyone to know off the top of their head whether they do use this, but if you do think that you do use this as a basis for processing data, then you're more than welcome to agree or disagree. But I think whilst we're doing that, so there's a couple of agrees coming through. I think whilst we're doing that, it's just a really useful reminder to just remind ourselves that consent is one option of a perfectly valid 6. So, as we've seen today from the first poll, many of you listening, if not all of you listening, do rely on consent as a basis for some of your processing. And if that's the most appropriate basis for your organisation, then that's absolutely fine. But it's just important to remember that there are a number of changes that we will see under GDPR. So if you are relying on consent, there's a couple of changes in terms of how you capture that consent and how you manage that consent. So we're just going to take a look at those in some more detail.
Before we do, Bethan, we've had a question come in just as you were talking about performance of a contract. Rebecca has asked, would this include grant funder requirement?
Okay, so what I would do in terms of finding which is the most valid basis is to look at these 6 conditions that are available. It depends. I imagine that you need the data for grant funding requirements. So consent is very unlikely to be the most appropriate option. You might be looking at, and again, it's hard for the ICO to say because we can't, without sitting down and looking at exactly what you have to provide. I don't know, I'm just thinking, Emma, would you, given your knowledge of the sector?
Yeah, I think this is probably something that we'll need to look into and get back to Rebecca if that's okay.
So it's one of those situations where have a look at these 6, because under the current Data Protection Act, you would be meeting one under the current law. So under GDPR, they will look very similar. But with consent, it's only to be used where you've got the ability to give someone control over that. So if you need to process information for grant funding requirements, you wouldn't necessarily get the consent of someone, because if you then get the consent and they revoke that consent, you've probably still more than likely got to use that data for grant funding requirements. So it's, in that scenario, consent is unlikely to be the most appropriate. Right, so let's just have a look at what GDPR says about consent and what you need to think about if you are relying on consent as a basis. So first of all, and as I've just mentioned, consent needs to be freely given. So by this, we mean that if an individual gives their consent, they should be able to have genuine choice and control over whether their data is processed. That means that they should be able to revoke it as easily as they gave it in the first place. So some organisations, especially in the marketing sector, use things such as preference management tools. So you log onto a website and you can easily change your mind about having, for example, postal marketing or email marketing. If an individual revokes their consent and you're able to rely on another legal basis under GDPR to continue to use their data, then that suggests that it wasn't valid consent in the first place because you're not offering them genuine choice. Because if they revoke their consent, you then flip to one of the other bases that we saw in the previous slide, so you shouldn't have gone for consent in the first place. The second point is that in order for consent to be valid, you must be specific in terms of your identity, the purposes of the processing, and you must inform the individual of their right to withdraw consent at any time. So you must be specific and quite informed about what you're telling them. It must also be clear to the individual what they're consenting to. So there must be no other interpretation of what you'll do with their information. So it needs to be unambiguous in that sense. And consent under GDPR must be granular. So by that, we mean that if there's a number of different processing options that they're consenting to, then there will need to be separate consents in place. So an example of that would be if your charity is asking someone whether they consent to receiving marketing, you wouldn't ask them, do you consent to marketing in general? You would need to break down that consent into separate components. So you'd need to ask them to consent to separate types such as email, postal, and telephone marketing. So it's about giving them as much control and choice over what they're consenting to. And finally, and this is quite a big change, consent under GDPR requires the individual to take an affirmative action to opt in. So that means that charities and other organisations across the UK that are relying on pre-ticked boxes currently wouldn't be valid consent under GDPR. So I, as an individual, if I'm consenting to something from a charity, I need to physically take a positive action to opt in, whether that's me ticking a box, whether it's verbally agreeing with someone over the phone that yes, I consent to my data being used in that way. Organisations can't also infer consent by silence or inactivity. So you can't write out to a group of individuals and say, unless we hear back from you, we assume that we've got your consent to do this processing. So whilst GDPR doesn't require organisations to automatically relook at their existing consent mechanisms, if the way that you did seek consent from individuals under the current law doesn't comply with these requirements under GDPR, then you will need to have a look at them and review them before May next year. So these 5 key points on the screen, if they don't meet, so if you do rely on consent and your mechanisms to get that consent don't rely on these 5 points, then you will need to review consent ahead of May next year. But again, we've got some really good guidance on our website. At the moment, we've got a draft consent guidance. If you just type in draft consent GDPR, it will come up on the search facility of the ICO's website. The final version, I think, is due in around December, but that guidance in itself, even in draft form, has got a wealth of information that will assist you when looking at what you need to change when you're getting consent. So I completely appreciate that today's webinar has provided you with lots of food for thought and has hopefully increased your confidence in terms of preparing for when the law does change next year. But before we come to the end and take some final questions, let's just recap quickly what we've been over. So we firstly looked at privacy notices. So what is a privacy notice? What information should one typically include? And we also looked at the scenarios where the need to communicate privacy information actively is strongest. We then looked at consent under GDPR, and it was a brief overview, I'll admit. So again, I would suggest looking at our draft GDPR consent guidance, but the key points from that was GDPR isn't just about consent. There's 6 legal bases to rely on to use personal data. So if there's any areas of your business where you do use consent and you think, well, actually, I don't think that's the most appropriate because we're unable to give that individual full choice and control, then have a look at the other ones available and document that ahead of GDPR, so document what you're relying on. And finally, whilst the issues of privacy notices and consent aren't new terms to the field of data protection, the standard of both will be raised massively when the law does change in May next year. So in order to prepare effectively, I would strongly recommend signing up to the ICO's e-newsletter. You can do so on our website. And keep an eye on our website, particularly the DP reform section that I linked to earlier. But please also feel free to contact me with any queries that you might have, and you'll see my details on the screen there. And I think if everyone's happy with that, we'll take some questions now.
Okay, thank you very much, Bethan. So if anybody's got any questions, if they can type them into the chat pane, please, and we'll answer them as soon as possible. Okay, so thank you, Marie. We have a question there. What is our own obligation if the data was given by another, i.e. referring agency?
Okay, thanks for that, Marie. That's a good question. Once you become what we call the data controller for that information, so once you're the ones that you've got that information and you're deciding what happens to that, then your obligations are exactly the same as any other organisation that also holds that. So you'd be responsible for complying with the GDPR and the Data Protection Act before May next year. That table that I referred to earlier, so the table on page 14, it's got 2 really nice columns, and it says what information you need to tell individuals and at what point. So if you're getting that information from a referring agency, you're not getting it directly from the data subject themselves. So you'd need to have a look on the right-hand side of that table to see what bits of information you need to let those individuals know that have been referred to you.
Okay, great, thank you. And then the next question is from Sarah. What consent do you need for CCTV?
Well, that's a really good question because that links in nicely to what we've discussed. So if you think realistically, that bit about giving people genuine choice and control over their data, you wouldn't be able to offer them that ability to revoke their consent if that was your legal basis for using CCTV. So if you can imagine Joe Bloggs walking past your office every day, you wouldn't be able to go out into the street, intercept him as he's walking past and get a positive action from him that he consents to being captured on that CCTV. So this question is a really good one to look at. What other bases are available for your organisation to rely on? So even if it's not consent you're relying on for processing, the fair processing information is still key. So you'd still need to make sure that for CCTV, you've got signage up in place. So you've got a clear sign that says, on the outside of a building or in a public reception area, you'd say, CCTV is in operation. It's run by WCVA, for example. To contact us for more information, please write to us on the below address. So CCTV is definitely covered if it captures personal data, but consent is very unlikely to be that legal basis that you would go for.
And also, probably, would you need to explain what you're using it for? Would you say, Bethan?
Yeah, so most CCTV would be used for something like crime prevention and detection. The need to kind of actively communicate what you're using it for is stronger if that falls outside of my expectations. So if I'm walking past a street in Cardiff and I see CCTV on a busy kind of road with a lot of restaurants, etc., then I might think, okay, that's likely to be crime prevention and detection. If there was CCTV installed within a corridor in my workplace, then I'd be quite kind of surprised at the use of that. So there's always a clearer kind of need to say what it's being used for if it would fall outside of my expectations. That's a good question as well. Thank you.
Thank you. Okay, so question from Sarah. If someone completes a keep in touch form but does not select their interests, can we write or email them and ask them what they'd like to hear from us, or are we unable to add their details to our database?
Now, this is one where there's probably no black or white answer on the top of my head, but it is one where that granularity is going to be key. So I think at this stage I would sit down and have a look at what you do write in that keep in touch form and see how you do get that person's consent to then keep in touch. So is it just by filling in the form, they're then added on the basis of consent? If there is a clear way of, if it is consent you're going for, especially if it's electronic marketing, then it will have to be consent because it links with the privacy and electronic communication regulations. So that granularity is key. So if they've got interests, then listing those interests separately and letting them have that control over what they choose, that will be key to look at ahead of May next year.
Okay, and a question, is there a list of legitimate interests?
So there's not a nice little list in the Data Protection Act itself, because the Data Protection Act applies to a whole range of organisations across the UK. But what we do say is that, first of all, there is good guidance at a European level. So if you enter into Google Article 29, I know this sounds very techy, but Article 29, legitimate interest, it should hopefully link to a nice little bit of guidance that was carried out on a European level. Now, that guidance kind of reflects your considerations when you're relying on legitimate interest. So again, it's not enough to just say that my organisation is interested in collecting this data. You have to look at three kind of key things. So you need to look at, well, is this interest legitimate, first of all? Is the data that I need going to help me achieve that? So only making sure you're collecting relevant information. And then you've got to make sure then that what you're trying to kind of achieve isn't outweighing the individual's fundamental rights to privacy. So there's not a list of legitimate interests because they can range massively from charity to charity and from charity to private sector to public sector. But it is important to just note that it's not just simple enough to have a legitimate interest.
And just to reiterate, you referred to the Article 29 legitimate interests.
Yeah, so if you pop that into Google, it should hopefully link to the Article 29 guidance.
Okay, and a question from Rebecca. Do you need to inform people where you outsource services such as CRMs or IT support, and these providers can access their information to provide this service?
Okay, so this is a good question because this is bringing in the definition of, I mentioned earlier, data controller. So the organisation that has responsibility for deciding what information is used and how. If you outsource certain parts of personal data processing, such as IT support, then that organisation is likely to become what we call a data processor. So they are simply acting on your instructions. Now, although you might include information in your privacy notice, because you're still maintaining as that charity or that organisation, you've still got control over what happens to that data, then you don't need to specifically list exactly what companies you're using for those data processing. It would be different if you're physically sharing that information with an IT support company for them to use for a completely different purpose. And, by passing that information on, they were then going to start doing whatever they wanted with it. That's a completely different relationship. And in that scenario, they would become data controllers, and they would need to make sure that they're adhering to the principles of the Data Protection Act. So I hope that answers your question. Thank you.
Would you need a data processing agreement, or would you suggest that that is
so any scenario where you use a third party to process data on your behalf, particularly under GDPR, this is going to become even more important. You do need a robust contract, because it's you as organisation A saying to organisation B, this is what we want to do with this data. You are to only act on our instructions as per this contract.
And does the ICO have any guidance on the data processing agreement side of things?
We've got a really good piece of guidance about the information governance implications of using a data processor. So again, like with many of these topics, our website is really easy to navigate, but I often find that simply typing in something into the search box gets you to that guidance more or less straight away. So if you type in data controller or data processor, then one of the first links that appears will hopefully be that nice little bit of guidance we've got.
Great, okay. And next question, if we pass data of people to another company, for example a funder, how do I know that organisation is being compliant with GDPR? Am I still responsible as an organisation as I have collated that data and passed that data on? The data is passed on to make sure the person is the right age for funding.
So you're certainly the data controller for certain elements of that. If you're required to pass that information on for funding purposes, and that second organisation that's receiving it then dictates what they do with that data, then they also become a data controller. So you would need to satisfy yourself that when individuals come to your organisation, they know that you will pass that data on. So that data passing can't come out of the blue to them. So certainly you're obliged to let them know that fair processing information. But then once that other organisation has that information, if they're using it for their own purposes, then they also need to make sure that what they're doing has been communicated fairly to that individual and that they are complying with the Data Protection Act as a whole.
Okay, great. Thank you, Bethan. So, unless we've got any more questions coming through, I think, great, okay. So, thank you very much, everybody, for attending our webinar this morning, and apologies again for the technical issues which occurred at the start of this session. We have on the screen there, you can see a link to a survey. If you can help us to improve our delivery of webinars by completing the survey, that would be much appreciated. Our next session is on direct marketing and the privacy and electronic communications regulations, and that's going to